In this video, we're going to be looking at issue and service of summons, and we are going to be unpacking summons in material detail. We are going to define, among others, what summons are. We'll also look on whom a summons served. We will proceed to look on who may serve summons, how are summons actually served. We are also going to be looking at that in detail. Then we'll also look at what is the time within which summons are supposed to be served and carried out? How do you serve government summons? We'll also be looking at how do you serve a corporation or a firm. We'll also look at how do you serve a partnership, the summons. Then also, how do you make a proper return of service after making or carrying out this summons? How do you carry out a proper return of service of these summons? Then what is substituted service? We're going to define it, look at it in detail, and how it is actually done. And then also we'll look at service by electronic means. This is through Facebook, WhatsApp, Twitter, among others, or even email. And then also in this video, we're going to be looking at what is the procedure of substituted service, and then how to serve a person who is in prison, and then finally, how do you serve public officers or even soldiers? Hello there, my name is Mutiaba Conrad. I am a lawyer and a private law tutor. And before we start on our class, I encourage you to ensure that you subscribe to this channel. And this is really important to you because every time I release videos, this will always be brought to your attention and you will not miss out on any single video. And then also, please ensure that you turn on the notification so that this is always brought to your attention every time I release videos. And then finally, students interested in private law tutorial sessions, please feel free to contact us. Our numbers are down in the description box. If you are at LLB, if you are at LDC, or if you're doing your master's, please contact us. We'll be able to give you those private law tutorial sessions to ensure that your grades are improved, so that you're able to excel in your legal career or whatever type of course that you're doing. So let's jump right into our topic today. As we said earlier, we are going to be looking at service of summons, a very, very vital topic and aspect you should know as pertaining civil procedure. And we are going to be unpacking it in material detail. And we are going to start by looking at the definition of summons. So what are summons? Basically, every time we talk about summons, ladies and gentlemen, here what we mean is that this is an official order. Okay, so this is an order of court, okay, requiring a person to attend court either to answer a claim or a charge or to give evidence. So summons here, basically, court is calling upon you, court is giving you an order to enter appearance before it, to either answer yourself to a charge or a claim or to even give evidence. So, having looked at what summons are, let's also look at about one or two principles governing it. It's also important to note that basically summons are governed by Order 5 under the Civil Procedure Rules. So every time you want to look at the principles governing summons, you just have to unpack Order 5 and case law so that you're able to understand what actually summons are about. So when you read under Order 5, Rule 1, Sub-Rule 5, it actually provides that summons must be signed and sealed by court. This is really very important, less of which they are a nullity. That's the position of the law. Please look at the case of Cow versus City Automate, case of 1967, East Africa, page 108, which provided that if summons are not signed and sealed by court, the same is a nullity. Then also important to note, under Order 5, Rule 2 of the Civil Procedure Rules, it requires that such summons must be accompanied by a copy of a plaint, a summary of evidence, and witnesses and authorities as to accompany such summons. So having defined what summons are, what must accompany the summons, and the requirement that they must always be signed and sealed, and that's the position of the law under Order 5 Rule 1 and Order 5 Rule 2, let's now proceed to look on whom a summons served. So after getting these summons from court, on whom do you serve them? The position of the law under Order 5 Rule 1 Sub-Rule 4, ladies and gentlemen, of the Civil Procedure Rules is that summons are served on the defendant in person or a recognized agent of the defendant or an advocate who is duly instructed. This must be an advocate instructed to represent the defendant. Then important also to note is that service on a recognized agent is as effectual as that served on the defendant himself. Now, we have looked on whom summons are served. Let's now proceed to look on who may serve these summons. What is the position of the law on who is supposed to serve these summons? Who must serve them? Ladies and gentlemen, I invite you to look at Order 5, Rule 7, Sub-Rule 1A of the Civil Procedure Rules. It's very elaborative on that aspect, and it clearly provides that any person authorized by court, that is number 1, number 2, an advocate, and number 3, an advocate's clerk, approved by court generally to effect service of process. So basically, that is who may serve summons. Let's now proceed to look at how a summons served. The entire process of service of summons, how is it carried out, and what are the legal principles governing the same? What you have to know from the onset is that these summons can either be served on the defendant personally or his agent. So any of those two is good. So if you're able to serve the defendant, that's good. If you're able to serve the agent, that's good as well. Even when the person to be served refuses to accept documents or personal service, okay, of such summons, personal service is deemed to be effected, provided the documents are made known to him. This is very important. If you proceed to serve the defendant and the defendant refuses, you make the summons known to him, he refuses, court always has the discretion to declare that such service has been effected upon the defendant. So it's not true that every time you go to serve the defendant, he must accept. Because you may go, serve him, introduce yourself, tell him the purpose why you're there and the documents that you're serving him, and he refuses. He refuses to acknowledge receipt. He runs away after listening to you and getting to know the purpose of your visit. So will it be taken that service has not been carried out? The answer is no. Court has the discretion, okay, to choose and declare that such service has been carried out. Also of interest, I invite you to look at Order 5, Rule 10 of the Civil Procedure Rules, together with the case of Erukana Omuchilo versus Ayub Machwira. It's a case of 1966, East Africa, page 229. In this case, and those two authorities that I've shared with you, service shall be made to the defendant personally, unless they have a recognized agent, which would be sufficient. So the position of the law is that you should always try and do your best to ensure that the service is done on the defendant or their recognized agent, and any of the same would be sufficient. Then also interestingly, in the case of Chigundu versus Kasuja, a case of 1971 HCB, page 163, the High Court of the Republic of Uganda has held that if proper effort to make personal service fails, then service can be made to an agent, for example, a wife or an advocate. And then also under Order 5, Rule 11, and the case of UTC versus Katongole, 1975 HCP, page 336, service on an agent with whom the defendant carries on business is good service. Okay, very important to note there. And then also in the case of Tindarwesire versus Kabale Town Castle, a case of 1980 HCB, page 33, court held that after serving an agent, the plaintiff is supposed to file an affidavit of service. And we're going to be looking at this later on in material detail, how to execute an affidavit of service. But that is the position of the law. The moment you serve the defendant, you have to proceed, or even an agent, to ensure that you file an affidavit of service. That's a position of the law. Let's proceed now and look at Order 5, Rule 13 of the Civil Procedure Rules, which basically provides that service can also be made on an adult member of the family residing with the defendant or an agent that is duly empowered. So that can also be good service as well. And also in that case that I earlier shared with you of Chigundu versus Kasuja, court basically held that if service is not effected on the defendant personally and the wife of the defendant is served, but the wife refuses to sign, this service is not effective. That's really very important to note, and that's the position of the law under case law. Then also let's proceed and look at the case of Balemezi versus Wanderi. It's a case of 1991, High Court Bullet, page 58. Basically, court held that service upon a wife of a defendant who is known to have traveled abroad is not effective service. So if you proceed to serve a defendant and you know that the defendant has traveled abroad or they are not around, you are in the know, but you still proceed to serve the wife of that defendant, court has held that the same would not be effective service. Now, important to note also, under Order 5, Rule 14 of the Civil Procedure Rules, where summons are delivered to the defendant personally or their agent or any other person, such persons are required to acknowledge service. That's the position of the law. So if you're the defendant, summons are served onto you, the position of the law is that you have to acknowledge such service. But however, the failure of which means that the service has not been effected. That's the position of the law, except that if the defendant or any other has refused to acknowledge the service, the court may declare the summons duly served under Order 5, Rule 14 of the Civil Procedure Rules. So the position of the law is that if summons are served upon you, you have to acknowledge. And if there is no acknowledgement, then service will be deemed not to be effected. But also important to note that court has the discretion to go on according to the facts and the narration in the affidavit. Court can declare that indeed service has been carried out effectively. In the case of Waswa versus Ochola, please look at it, a decision of 1991, ULSLR, page 161. Court held that the address of the person identifying the individual to be served must be included into the affidavit of service. So if you swear the affidavit of service, you must include the address of the individual who you went to serve. This is really, really very important. And just to throw more light on this, I encourage you to further look at Order 5, Rule 16 of the Civil Procedure Rules, which basically provides that whenever summons are served, the person who effected service must annex an affidavit of service stating the time when and the manner in which the summons was served and the name and address of the person, if any, identifying the person served, and of course witnessing the delivery and tender of summons. So Order 5, Rule 16 tells you what you have to include in your affidavit of service, and this is really, really very, very, very important. Also, the decision of Automobiles versus Kampala Bus Service, a decision of 1966, East Africa, page 480, court has held that failure to record the name and the address of the person identifying the person to be served renders the affidavit of service incurably defective. So your affidavit of service will be incurably defective in case you, after service, don't go on to include the name and the address of the person identifying the person to be served. That is really, 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 really important. I cannot overemphasize the importance on this, on summons, because the case can always be lost, really, and it can have a very bad start if you don't carry out the aspect of service of summons effectively. So let's now, having looked at the principles, the position of the law, and how the summons are actually served, ladies and gentlemen, let's now proceed to look at what is the time of service. So within what timeline must you carry out the service of summons? This is really very important. Time is of essence to lawyers and clients in matters, so you must always know when are you supposed to execute these summons. Can you execute them late in the night at 1 a.m. in the night? What is the timelines? Okay, so timelines are important. Order 51, Rule 9 of the Civil Procedure Rules is very elaborate on this aspect. Service on a Sunday is void. Okay, that's the position of the law. So please do not proceed to serve a defendant on Sunday. Such service would be void. Also look at the case of Waswa versus Ochola, where court went on to hold that save for summons to file a defense, all other notices, pleadings can't be effected on a Sunday. So the rules are very clear. Case law is very clear. Please do not proceed to do the same. Then also under Order 51, Rule 2, service on public holidays is as well prohibited. So that is really very important to note. Proceed also and look at Order 51, Rule 9 of the Civil Procedure Rules, which basically provides that service can be effected any time of the day of the week. And then also number 2, service after 1 o'clock on the weekend shall be deemed to be effected on the following day in case of a weekday. And then lastly, service on a weekend after 1 o'clock on Saturday is deemed effected on Monday. So there's that aspect of postponement of time where you serve after certain timelines on the weekend. Service is deemed to have been carried out the next day, such as a Monday. So very, very important. But again, ladies and gentlemen, I cannot leave out Order 5, Rule 1 and Rule 2 of the Civil Procedure Rules. It's very important because it provides that service of summons shall be effected within 21 days from the date of issue. So very, very important. The timelines within which you have to carry out the service of these summons are 21 days from the time when these summons are actually granted by court. The only exception, ladies and gentlemen, is where time has been extended by court, of course, on application, and this application must be made within 15 days after the expiration of the 21 days, showing sufficient reasons for extension. So if you don't serve the summons within 21 days from the time of issue, then you have another 15 days after the expiration of the 21 days within which to put in an application and apply for an extension. This is really very important. Please know the effect. What happens if you don't serve summons within 21 days? Please look at Order 5, Rule 1, Sub Rule 3. It is very effective on the same, and it provides that where there is no extension of time, the suit shall be dismissed. So court doesn't take simply the aspect of timelines, and it will go on to dismiss your suit in case you don't execute these summons within a provided timeline. So let's now proceed to look at how is government served summons. So remember, there are incidences where government can really fault you, okay, and a time may come where you really have to serve them summons. But how is this carried out, ladies and gentlemen? Please, I invite you to look at Article 250. Clause 2 of the Constitution of the Republic of Uganda. It's very clear, and not just even the Uganda alone, but also in most constitutions of other countries around Africa. Just look into your constitution. I know I have so many subscribers that watch these classes from especially Kenya, from Zambia, from South Africa, and Nigeria. Please look into your constitution or your acts. There are provisions providing that all documents required to be served on government must be served upon the Attorney General, who is always the legal representative of the government. Very important there to note. And Rule 5 of the Civil Procedure Government Proceeding Rules is very elaborate. It in essence provides that service on the Attorney General is effected by delivering summons to the Attorney General's chambers and shall not be deemed complete until the Attorney General or an advocate entitled to practice in the Attorney General's office acknowledges service. So it should be a person who is entitled to practice as an advocate and in the AG's chambers who must acknowledge service, or the Attorney General himself, less of which such service on government would not be complete. Also, service on the Attorney General, of course, in practice, it's done at their chamber registry and a copy is returned stamped. And also Rule 11 is very clear, and it provides that government has 30 days to file a defense. So the moment you serve them the summons, they have 30 days to ensure that they put in a defense to the same. Let's now proceed, ladies and gentlemen, to look at how is a corporation or a firm served. How do you serve its summons? This is really very important because you'll find yourself in a situation whereby you have to serve a firm or a corporation. How do you do that? Let's look at the position of the law under Section 274 of the Companies Act 2012. It provides that a document is served on the office of the company by either one, sending it to the registered postal address of the company, so you can send it on the box number of the company. That's one way of serving the company or firm. But then also secondly, by sending an email to the non-electronic address of that corporation. That's also very important as well. And then finally, leaving it at the registered office of the company, you can physically take it there and deliver it. The position of the law, it allows for that for purposes of corporation and companies. Let's now proceed to look at Order 29, Rule 2, and the case of Java versus Segane. It's a case of 1972, Volume 2, Uganda Law Reports, page 108. It provides basically court held that summons against a corporation may be served. So court was trying to elaborate on how you can proceed to serve a corporation, and it went on to say you can actually serve the secretary or the director or the principal officer of the corporation. this is also good. And then lastly, you can also do the same by leaving or sending it to the corporation's registered office or known place of carrying on business. That is also allowed according to case law, which I just shared with you. Then also the case of Jala versus Enago project. The citation is 1988 to 1998 CB, page 157. Basically, court went on to hold that whenever there is a board secretary and general manager, service ought to be done on them. This is really very important to note. And then secondly, also court went on to hold that service on a manager is not proper service, as he's not a principal officer. Remember, we looked, ladies and gentlemen, at Order 29 Rule 2, which provided that summons against a corporation may be served on the secretary or director or principal officer. So court has gone on to guide in Jala versus Enago project that a manager is not a principal officer, and therefore service on such a person in a company would not be proper. Then also finally, ladies and gentlemen, the case of Serwada versus Popular Tours and Travel Limited is authoritative. 1981 HCB, page 29, court held that time does not begin to run against the defendant until properly served. So we'll be looking at the aspect of time and limitations later on. There are already so many classes on this channel. Please look them up. But basically here what we are saying is that in terms of time, time does not begin to run. We don't start to count the time unless a service has been properly effected. Let's now proceed, ladies and gentlemen, to look at how do you serve a partnership. But before we proceed into service of partnership, I just want to remind you that please, in case you need help, in case you're struggling, you need some mentorship, you need guidance, you need private law tutorial sessions, please contact us. Our numbers are down in the description box. Just contact us. We'll be able to help you to improve your grades. Low grades are really important, and the mentorship, the guidance from experts like us and our team are very fundamental to ensure that you succeed in your law school. And then also, of course, we help to guide you so that you do not do some of the mistakes that we did when we were still students in school. We help to mentor you so that we put you on a proper path. And students who have always been on our private law tutorial sessions have been continuously proven to outperform their fellow colleagues who do not have any sort of mentorship. So please contact us. Our numbers are down in the description box. So let's quickly look at how do you serve a partnership. So service on a partnership, how is this even carried out? Ladies and gentlemen, look at Order 30, Rule 3 of the Civil Procedure Rules. It's very elaborate on that, and it provides that where persons are sued in the name of their firm, the summons shall be served one upon any one or more of the partners. So if you serve one of the partners or two or three of them, that is service done well to a partnership. Or number two, at the principal place at which the partnership business is carried on. So if they have their office, proceed there, serve them. And then finally, the other way is as the court may direct. So in case court directs you to carry out this service in a certain way, then you can go on and do that service. Let's now proceed finally to look at how to make a proper return of service. So after your services have been carried out, how do you make a proper return of service? What's the position of the law, and what must you do? So once service of process is effected, the process server must swear an affidavit of service with court. The process server is the person who goes on to effect service. So they have to ensure that they swear an affidavit of service. This is really very important. And in case you really don't swear an affidavit of service, this service can be deemed not to have been carried out. Please, I invite you to look at Order 5, Rule 16 of the Civil Procedure Rules, which basically provides for what an affidavit of service must state. So when you're making a return of service, the affidavit of service must, as a matter of law, include the following. Number one, time when service was effected on the defendant. You have to tell us what was the time when you actually proceeded to effect the summons. Then number two, the manner in which the summons were served. You have to go on and clearly elaborate the manner in which these summons were carried out. And then number three, the name and address of the person, identifying the person served, as was held in Miss Automobiles versus Kampala Bus Services. We already looked at this case in material detail, and we said this can be very fatal in case you leave it out. And then number 4 is the exact place where the service was effected. You have to tell us the area. Where was the service effected? And then number 5, whether or not the person served is known to the person the summons is meant for, and if the person is not known to the process server. So you have to include all these details. They are very important. And then also, if no personal service, the person should indicate the relationship between the person served and the person summons were directed at, and the source of information above must be stated as well. Very important aspect to include in the affidavit. And then finally, that he required his or her signature and her or his response. So you have to inform court that you asked for the signature of this person and what response did they give you. You can either say they refused, they ran away, they chased me away, or they actually complied and signed on those documents. Now, it's important to note, ladies and gentlemen, that non-compliance with any of the above would make any such service fatally defective. This is really important to note. And then also under Order 5, Rule 17 of the Civil Procedure Rules, it provides that court shall examine the serving officer of summons on oath touching his or her proceedings and may make full or further inquiries. So court can examine actually the process server to ensure that actually this service was carried out effectively, and court may declare or order as it actually sees fit. And then also finally, before we move on another aspect, in the case of Edison Kanyabwera versus Paston Tumwebaze, this is a Supreme Court decision number 6 of 2004. Actually, court held that the provisions of Order 5, Rule 17 are mandatory, and you always have to ensure that you comply to them. Let's now proceed, ladies and gentlemen, to look at substituted service within jurisdiction. So there is something known as substituted service. We want to look at it. How is it actually done? And what is it in essence? First of all, I invite you to look at Order 5, Rule 18 of the Civil Procedure Rules, which basically provides that court can order for substituted service if it's satisfied that summons can't be served in the ordinary way. So in case you look for the defendant, you've tried to look for them, or maybe service has failed to be carried out, court has powers to ensure that substituted service is carried out. And in essence, substituted service is some other way of carrying out service apart from serving the defendant personally. Now, can't be served in the ordinary way. What this one includes, it includes the case where the defendant, having knowledge of the existence of the summons, actually evades service. So you've been looking for the defendant, they know about the summons, but they are evading service. Then you can actually opt for substituted service. Then also in the case of Erukana or Mochilo, we already looked at this case in detail. Machiwa, court held that substituted service can be by advertisement, by carrying out advertisements in newspapers or affixing a copy in some conspicuous part in the court or part of the house. So substituted service can be carried out through advertisements or even going on to ensure that you affix a copy in some public place of the house of the defendant, such as their main door or on the gate or somewhere where you can affix such types of summons. Then finally, under Order 5, Rule 31 of the Civil Procedure Rules, where government is requested to effect foreign legal process in Uganda under Order 5, Rule 30, it may do it on application by substituted service. So government is also allowed, in case there is a procedure or a requirement for government to carry out service here to a citizen, it can actually do it by substituted service. Please look at Order 5, Rule 31 and Order 5, Rule 30. Read them together and they will be more elaborative on that aspect. Now let's quickly look at service by electronic means such as Twitter, Facebook, WhatsApp, or any other, even email. What is the position of the law? Can you actually serve a defendant through these very popular social media platforms? And the answer is yes, ladies and gentlemen, and the law actually allows for it and provides for the same. I invite you to look at Order 5, Rule 18 of the Civil Procedure Rules, which basically allows this mode of service when it actually states, open quotations, such other manner as court thinks fit. So court can feel it fit depending on the circumstances, and actually court can order that such service be carried out to the defendant on these social media platforms such as Facebook, Twitter, YouTube, WhatsApp, or even email, and the party can ask court for an alternative service by email or Facebook or Twitter or WhatsApp. This is just an alternative means of service if physical personal service cannot be effected. So if you can't effect this service personally, you can go to court and apply, and court can allow you to carry out the same. Then finally, under Section 274 of the Companies Act, a company can be served by email to its non-electronic address. So that's the position of the law. So the law allows you to serve a company by email on its non-electronic advice. Please look at Section 274 of the Companies Act. It's very authoritative on the same. Let's now proceed to look at what is the procedure for substituted service. So if you're going to carry out substituted service, how do you even proceed to do this? What are the procedures? What are the documents? And what is the forum? Of course, the forum is the court in which the suit is, but also under Order 51, Rule 31 of the Civil Procedure Rules, it actually provides that the applicant applies ex parte to court by summons in chambers supported by an affidavit. So the documents you use are chamber summons, you support them with an affidavit, and of course, the affidavit must state in it in material detail the date when the summons were issued by court, number 2, the occasions on which personal service of the summons was attempted, and of course the facts upon which such inference of service was based, and then number 3, the believed address of the defendant, and also finally that the substituted service is the best method by which the summons will come within the defendant's knowledge. So you have to include all those aspects in your affidavit. And then finally, of course, court grants the application and the applicant executes it in the terms granted. So that is the procedure basically. It is by chamber summons supported by affidavit. The affidavit under the provisions of Order 5 Rule 32, it has to include certain aspects. Please ensure to include them or else your affidavit could be defective. Let's now proceed to look at how do you serve a person confined in prison. So what if the defendant is actually in prison, he's in Luzira Maximum Prison or any other prison? How do you proceed to even carry out service onto these persons? Please look at Order 5 Rule 19 of the Civil Procedure Rules. It's very elaborative on this aspect, and it provides that summons are delivered or sent by post or otherwise to the officer in charge of the person for service on the defendant. So you basically serve the officer who is in charge in prisons, who then proceeds to serve the defendant. And under Order 5 Rule 20 of the Civil Procedure Rules, it actually provides that that officer or such officer in charge of the prison is bound to serve such summons and return them with a duplicate under his sign to acknowledge that actually he himself went on to serve the defendant in the prison with a written acknowledgement by the defendant. So this officer has to go on, serve the defendant, then signs, also attaches the acknowledgement by the defendant who is in prison. So ladies and gentlemen, that is how you basically serve a person who is confined in civil prison. Let's now proceed to look at how do you serve public officers and soldiers. For example, soldiers, how do you even do that? So for public officers, authorities, Order 5 Rule 20, Sub-Rule 1 of the Civil Procedure Rules, which basically provides that service the head of office in which the defendant is employed. So if it is a public officer, the person heading the office in which such public officer is employed is the person who you will serve. That's the position of the law. Then as pertains soldiers, what you have to note from the onset, this is very important, is that a soldier doesn't include an officer. Please distinguish between a soldier and officer. For example, these persons who work in the army barracks, who cook food, and they are not soldiers, those ones, they don't include soldiers. When we talk about a soldier, we mean a soldier in the legal sense. The position of the law is under Order 5 Rule 20, Sub-Rule 2 of the Civil Procedure Rules, and it basically provides that service is on the commanding officer of the soldier. So if you're serving a soldier, ladies and gentlemen, you serve their commanding officer, and that would be a good service under the law. Then also under Order 5 Rule 20 of the Civil Procedure Rules, it actually goes on to say that such head of office of a public officer or commanding officer of the soldier is bound to make service and return the duplicate under his sign with the written acknowledgement of the defendant. I already talked about this. They have to go on, whether soldier, whether the head of office for public officers, it really doesn't matter. They are bound under the law to proceed and serve the defendant and then return a copy with an acknowledgement by the defendant, of course, who at that material time would be in the prison. So ladies and gentlemen, that's actually how you proceed to make a service on soldiers and public servants. So having explored service and issue of summons in material detail, ladies and gentlemen, we meet again in another class. I hope you've really found this class very helpful. Contact us. Our numbers are down in the description box. In case you need these private law tutorial sessions, we will be able to help you. Please contact us. Also, if you've not yet subscribed to this channel, you can clearly see that you need this knowledge, you need this information. So ensure that you subscribe. If you're using your phone, just put it in landscape mode and there will be a red button underneath. Just click on it. Also turn on the notification bell so that every time we release classes, this is always brought to your attention. We meet again in another class. Bye-bye. In case of any questions or comments, please just put them down and we'll be able to help you whenever we get time. Thank you very much. We meet again. Bye-bye.